Good evening to all of those that are logging in. The number is continuing to rise, so I'm going to give it a few seconds just to say welcome. Welcome to Popular by Demand, part 2 of a webinar of 3 amazing legal minds in this field of law. We are so excited to have our partners and friends join us tonight on the webinar. For those that are just coming on, we see the number continue to tick up. Welcome to part 2 of Supreme Court Breakdown. There is so much to get to tonight. And as Whitney said, we just experienced some storms that came through the DMV area. However, it looks like the storm is passing over, and we are definitely not moved by the winds and the rain. We're going to get this information out to you, all our listeners. We're so excited to have you tonight. We have a special panel. For those that joined us on the first event on July 17th, what a night we had. And as soon as we got off, the request came through. Is there a part 2? When is part 2? What is the date of part 2? And so we had to answer the call. So we're here 3 weeks later on August the 7th, 2023 with the panel of the year. Tona Boyd, Darielle Rodriguez, and Janice Mathis representing the Legal Defense Fund. Tona, Darielle representing the Leadership Conference on Civil Rights, and our very own General Counsel of the National Council of Negro Women, Janice L. Mathis. To my sisters, good evening. Thank you. Thank you for coming back. Thank you for not saying no. To our listeners, the numbers keep ticking up as those that are joining us. We had a large response to this webinar, and it's because of the 3 of you. And then tonight, through this panel, we're going to ask some of those questions that came in from our first webinar. We want to make sure that we got to the messages that came through from some of our listeners. Very pertinent questions, very detailed questions. Also, some things have happened since the last time we talked. Some new things have transpired, and so we want to discuss some of those issues. And then tonight, before we head out, we've got a very special guest. The good Reverend Al Sharpton is going to join us tonight. I don't know about you, but it has been 60 years, and we're going to be commemorating one of the most important public displays of civil rights advocacy, the March on Washington. And so we'll hear from Rev tonight, who will be giving us some content. For those of you that are on Facebook Live, we want to say thank you for logging on. Share this with your friends. Share it on your pages. Let the people know that we are here with the best of the best, talking about these legal issues that are really of concern for Black women and their families. So we're going to jump right in. There's no need to waste time. It's 34 after the hour for folks that are on. If you have a question, go ahead and get it ready. The Q&A function is open for you. The Q&A function for those that are logging in on the webinar, it is open for you. Now we're going to jump right in, because as soon as we got this conversation going last time, we talked a lot about student loan debt. And let me just say this, our panelists gave us some context, but we want to dig a little deeper because many of you started to ask some more questions. And so one of the things we want to start with, and I'm going to start with specifically looking at Janice as well as Darielle. We wanted to start off talking a little bit about student loan debt. Now, let me just give context here. Many students have gotten their notification, actually this past week, that student loan repayments are about to restart. And I know for the people that are listening, many students and their guardians have received notification that their repayments are about to begin. After the Supreme Court ruling, President Biden, he mentioned 2 measures that he would take to ease the burden of debt repayment. If you don't mind, can we talk a little bit more about what those measures are and specifically how they'll affect the Black community? So I'm sending this over to Darielle and Janice. Who wants to get us started on this, the 2 measures that have come down from the president and how that will affect Black communities?
Janice, do you want me to jump in?
Yeah, Darielle, why don't you go ahead?
Okay, great. Good evening, everybody. President Arline Bradley, thank you so much for having me. It's a real pleasure to be back on this panel with my esteemed colleagues, Ms. Janice Mathis and Ms. Tona Boyd. NCNW, thank you so much for gathering us and continuing this very important conversation. As you said, I do think it is critically important for us to push out this information so that our communities know what's actually happening with in the wake of these different rulings and with respect to actions that the administration is taking in response to these rulings. So with respect to student debt, as you mentioned, there was a negative ruling earlier in the summer that blocked the administration's student loan debt program, which would have resulted in significant debt relief for many borrowers, including Black and Brown borrowers who we know are disproportionately represented amongst those who own student debt. And in that case, the Lawyers Committee for Civil Rights, under law, we filed an amicus brief highlighting for the court the positive impacts that the debt relief would have had on Black communities in particular. Now, in the wake of the ruling, President Biden immediately announced that the administration would undertake a rulemaking to help design a new program to provide for broad debt relief. Now, we know that rulemaking can take a long time. That requires stakeholders submitting comments to the administration, identifying what this new program could look like. It'll require a lot of public hearings and negotiations. But in the interim, the Biden administration identified a couple of more immediate programs to provide relief to student debt borrowers. And the first is one that allows borrowers to provide a different path under the Higher Education Act, where borrowers who have been repaying their loans for 20 years or more under income repayment plans would be eligible for debt relief. He announced that those borrowers in particular could see about $39 billion of their loans automatically discharged as a result of fixes that the administration is making to the income-driven repayment plan program. Now, there's been a lot of research conducted about this program, about the income-driven repayment plan program, or the IDRs they're called. And what the research has shown is that it's been riddled with issues. It's been riddled with different flaws, including issues that have occurred at the hands of the student loan servicing companies like Navient. What they found was that as many as 8 million borrowers were eligible for these type of income-driven repayment programs that ultimately were supposed to result in discharge of debt. Even though as many as 8 million folks were eligible for relief under those types of plans, 2 years ago, an advocacy group called the National Consumer Law Center did some research and found that only 32 people had obtained relief under those income-driven repayment.
32 total people?
32.
32,000, no, 32 total.
Oh,
32, right? Which tells you that there were serious problems with the program. And some of those problems included the fact that loan servicers were steering borrowers away from these programs and instead steering them into forbearance programs. Now, forbearance programs provide a short respite, a short relief from repayment programs, but what ends up happening? You're still accruing interest, right? You're not ultimately able to discharge your debt. Research has shown too that loan servicers have not been providing debt holders with accurate information, the information necessary to understand what the requirements of the program are, how you can actually recertify and become eligible for debt relief. And so the Biden administration made a commitment to fix these issues and to ensure that folks who have been making payments for at least 20 years are eligible for debt relief. And you asked, what does a program like that mean in particular for Black and Brown communities? It's incredibly important for Black communities and Brown communities because, as I mentioned at the top of my comments, Black and Brown borrowers are disproportionately holding higher rates of debt, and they have higher rates of default. And research has shown that even in a program like this, the income driven repayment program, while Black borrowers are enrolled at a higher rate, they benefit less than white borrowers from the relief of that program. So it's critically important that this program be fixed and that it be fixed promptly. And that's what the Biden administration announced. It announced that borrowers who were making payments under those programs would start seeing relief as soon as later this month. Unfortunately, on Friday, this past Friday, the Cato Institute filed a lawsuit challenging that program. They also challenged another program that the Biden administration announced, which is aiming to make a one-time adjustment to the accounts of many student debt borrowers, folks who haven't had their payments tracked or accounted by student debt servicers. So the Cato Institute filed a lawsuit saying that these programs are not authorized, that they are unconstitutional. And I was taking a look at some of the news articles about this lawsuit, and a Department of Education official did put out a response and basically said that this lawsuit, and I'm quoting the official from the U.S. Department of Education, they said that this lawsuit is nothing but a desperate attempt from right-wing special interests to keep hundreds of thousands of borrowers in debt, even though those borrowers have earned the forgiveness that is promised through income-driven repayment plans. We're not going to back down or give an inch when it comes to defending working families. And when the Biden administration made those announcements, the Lawyers Committee applauded that move by the Biden administration, because we know that if this program is fixed, it could really provide significant relief to the communities that we serve. So we will continue to monitor the case, and we're hoping that this relief will come through for the millions of people who need it.
And first of all, I'm still on 32, and thinking about the number of people that have benefited from this. And I'm going to ask Janice to weigh in as well, and also give you some context, Janice. We had a question come in that's connected to this question that talks specifically about planned student loan debt relief for seniors who are still paying them off. So is there an age requirement for this loan payoff and for the programs that are available, or is there some kind of loan repayment plan that is different for persons who are over the age of 65? So that's kind of coming in too. So I want to combine that in terms of the impact on Black families, but also on Black seniors. Just want to give your insight on that as well.
Well, I want to thank you too, President Arline Bradley, for convening this session. It is good to be here with Sister Boyd and Sister Rodriguez, two bona fide experts. I want to go back to something that I think would provide, and others do too, would provide a more systemic solution for student loan debt. The United States Constitution gives American citizens the right to a fresh start in something called bankruptcy. Now, nobody wants to be bankrupt. It affects your credit. It stays on your record. It's an indication, some people think, of sort of a moral hazard or moral failure. This came up back in 2008 with the mortgage foreclosure crisis. But the advantages of bankruptcy, it's not a specialized program that is now for the people who benefit from a particular program. It's already enshrined in the United States Constitution. Years ago, when I was practicing bankruptcy law down in Georgia, they said, well, only taxes and child support could not be discharged in bankruptcy. Almost any kind of unsecured debt that does not have collateral attached to it,
right,
credit cards, medical bills, can be wiped out in either Chapter 13 or Chapter 7 type of bankruptcy. It's systematic. There are court systems already set up. There are bankruptcy trustees and creditors committees. It's highly regulated. Judges who specialize in how to reorganize debt. There are really plans of reorganization. There is no reason, except for the greed of lenders, why we could not treat many types of student loan debt in bankruptcy. And there's really no moral hazard, because you have to be insolvent in order to file a bankruptcy, which simply means you have to have more debt than you have assets. And so this is not something that I'm just coming up. Chuck Schumer and Dick Durbin, the senators from Illinois and New York, wrote a letter to the Department of Education last year asking the Department of Education and the Department of Justice to relax their opposition to discharging student loans in bankruptcy. Now, this has not received a lot of publicity. There was a documentary that ran, I think, on 60 Minutes on television talking about it, but I think we owe it to our United States senators to say to them, we want a systematic, orderly, equitable process for getting rid of student loan debt when it becomes so burdensome. President Arline Bradley, you saw the results of our survey last year, where people were talking about how it limited their life options and how it made them depressed. And people even talked about the fact that it made life not worth living to know that they've got this overhang of debt. We can do better for the American people. And I think that bankruptcy is something we ought to consider.
And that is, again, as you're thinking about some of the legal strategies, I just want to also lift up this conversation that's coming in and questions that are coming in addressing this issue. Student loan debt is really something that a lot of folks have not talked about this way, but as it's become a much more, I think more high awareness has been really put on this issue, has really helped Black families look at this as a civil rights issue. It has not been seen that way before. It was really this kind of shackled experience. Everybody has to pay their student loan debt, but when these programs come into play, as we're thinking about the role of financial disparities between Black families and others, Darry Lay really talked about those that are benefiting and those that are not. Again, this shows us why we have to interface in these civil rights conversations, particularly around student loan debt. And thank you for highlighting that, especially as we're thinking about seniors and we're thinking about those families that have been strapped. Navient is a word that I used for a very long time because I had to pay as well. And just thinking about the amount of money that we're putting out for even for our oldest daughter. I mean, these kinds of issues are continuing to come. So you all have really gotten us started. I want to give a special shout out. Some of our board members have logged on and started sending their questions. So our board chair is on. Dr. Lois Keith is here. Diane Larche, I see you. Joan Powell, Kimberly Underdo, and Michelle Higgins. Thank you all for calling in all over the country. They're in California, in Georgia, and DC. So thank you all for jumping on. I want to get to this next question because what is so interesting is that, and I'll tell you this, Janice, the Chuck Schumer piece and the Durbin piece was really helpful to give. Many of our listeners are asking, hey, do we need to follow up with Majority Leader Schumer? The answer is yes.
Yes.
Voters, yes, voters. Illinois, New York, we see you. Please stand up because we need to follow up on these issues. Look at how they need to think about relaxing their positions on some of these issues around bankruptcy, because this may be one of those strategies that's going to come from ground game work. Student loan debt, in the response to student loan debt, has been a ground game conversation. So absolutely stand up and speak out on this. Let me move on to the next question. I see you, Regina Majors. Thanks for calling in from Indiana. We want to talk a little bit about the state of Alabama. I don't know if folks are on from Alabama, but let me just say, Alabama, we've been watching Alabama for a very long time. Can somebody say Section 5? Can somebody think about all of these issues that have come from this state of Alabama? And I'm thinking about our sister, Congresswoman Terry Sewell, who has really been at the front line working on this. She's a proud member of NCNW, proud member of Alpha Kappa Alpha, who has been an affiliate of our organization and has been really at the forefront of having these conversations around congressional districts. Now, earlier this year, the Supreme Court made this shocking decision, hear me, listeners, that Alabama's congressional districts were drawn in a way that severely suppressed the votes of the Black constituency in that area, right? We were blown away. Now, I'm going to turn this over to Tona because I really want you to be able to get into some of this in depth. Can you discuss this case? Where does that case stand now? Because we were all in shock in a great way, right? But we want to talk a little more about this. Where does it stand now? And the history of how redistricting is used to suppress the will of Black voters. How do you see this case affecting that issue as well?
Sure. So thank you so much, President Arline Bradley, for having me. And I also want to thank my distinguished panelists for joining again. It's such an honor to be able to talk about the impact and the aftermath of these important Supreme Court decisions with you all and with this community. So Merrill versus Milligan, or Allen versus Milligan, is a voting rights case that the Legal Defense Fund has been litigating for the past almost 2 years. And that case arose back in 2021 when Alabama passed a racially discriminatory congressional map. And how did we know that? So we had the results of the 2020 census were published, and those showed that in Alabama, Black people comprise about 27 to 28% of the population. But Alabama drew a congressional map that only allotted one majority Black district. And so we filed a lawsuit because that map violated Section 2 of the Voting Rights Act. And we alleged that it violated it in 2 ways. First, it denied Black people in Alabama an equal opportunity to participate in the political process and to elect candidates of their choice. And the second way it violated Section 2 was that it intentionally packed and cracked Black communities in the state, which dilutes Black voting power. And so what happened was Alabama drew a map, and you've heard the word gerrymander. It was a racial gerrymander. So it's where you draw crazy lines that don't make sense, that don't honor communities of interest in order to dilute voting power. And so we filed a very strong case in the district court in Alabama. And in January of last year, the District Court of Alabama, a 3-panel sat and heard this case. 2 of the folks that were appointed to that panel had been appointed by President Trump, and 1 had been appointed, I believe, by President Obama. That panel unanimously found that Alabama's map violated Section 2 of the Voting Rights Act, and they ordered Alabama to draw a new map. And that new map was supposed to either have a composition in which a second district would be comprised of Black voters, a majority of Black voters, or close to a majority of Black voters. So the district court was clear. Alabama fought that decision, and they took it all the way to the Supreme Court. Just in June of this year, the Supreme Court decided with us. We won. They agreed with the district court that the map that Alabama drew likely violated Section 2 of the Voting Rights Act, and they sent it back for Alabama to draw a new map that had 2 majority Black congressional districts. So what happened when that got sent back to Alabama? Alabama defied the Supreme Court. Alabama defied their own district court, and they again drew a map that violates the Voting Rights Act and that dilutes Black political power in Alabama in a way that is unconstitutional and against our Voting Rights Act. And so where are we now? LDF has already filed an objection to that racial discriminatory map that Alabama has once again drawn. There will actually be a hearing next week in front of that very same district court panel that rejected Alabama's initial map. And that district court will have to decide whether or not they agree with our objection and believe that a new map should be drawn or not. Based on their prior case and their prior decision, we believe that we are on strong footing there. And so if the court agrees with our objection, they have the option then to appoint a special master, and that individual will propose and draw a new map that complies with the court's order and with what the Supreme Court ordered be done. And so that's where we are. We have federal law, we have precedent, we have the Supreme Court, we have democracy on our side. And so I think while what Alabama did was certainly appalling, it was lawless, the waste of taxpayer dollars, I want to flag that it's not new. We've seen Alabama defy court orders that are designed to remedy racial discrimination time and again. I think folks remember some of those iconic civil rights images when you had George Wallace, the infamous former governor of Alabama, trying to stand to physically block Black students from integrating the University of Alabama. But guess what? Alabama didn't win then, and they're not going to win now. So we're going to continue to fight and do what we have to do, whether that's going back to court, whether that's going back to the Supreme Court, to ensure that the Black Alabamians have the representation and the fair map that they deserve.
You know, Alabama's been in the news lately, and one of the things that we've been really keeping an eye on is the way that the courts have been showing themselves and the way that states have been responding. There was someone in the Q&A that asked, why are we marching on Washington and not marching on the states? And our goal is to march on both. We want to say it again, elections have consequences. So who you elect and who's appointed in these seats makes a difference. And so it's not a either or, it's always a both and strategy. When you're thinking about organizations like NCNW, like the LDF, like the Lawyers Committee on Civil Rights, these organizations are really aligning the best of the best in terms of our civil rights plans. How do we litigate? How do we agitate? And how do we educate? That is really what we're seeing. And with this case, please watch this closely. For folks that are in the state of Alabama, make your actual intention and your pleasure known as a voter in Alabama. You should be screaming aloud every section meeting, every chapter of our affiliates. For those that are in faith institutions, you should be talking about the way that maps have been drawn. Gerrymandering is as old as apple pie in America, okay? I want you to be clear to understand it. And also know that the only way this changes is if we are voting for the individuals who have our best interests, number one, in their hearts, but also if we decide to identify those that are qualified to run for office and make some of these decisions as well. This is a both and strategy for us. It is a state run and it's also a federal conversation. That's why the highest court in the land, my goodness, even had to get us to the point that say, my goodness, Alabama, you're wrong. Never thought I'd see it, but we saw it. Why? Because democracy is on our side. We are righteously in the right place. So I want to just actually thank you for that, Tona, because it really gives us context. Now, let me move on, because we, in our last conversation, we talked a little bit about race-based affirmative action. Now, let me just say, since we've met in July, there have been a number of lawsuits that have come out against organizations and corporations that have done specific work to advance Black businesses, Black women's businesses to be specific. There are some of the same people who filed suit against these universities that are filing suit against our sisters. Can we talk about affirmative action again? I want to bring it back and just do a quick highlight. And I'll bring this to Darielle actually. Why this diversity work is so important, not just in colleges and universities, but then that thinking about beyond colleges and universities. Why is race-based affirmative action and this ruling, why is it making a difference? And that's what some of us asked in our last conversation, but give us more context there.
So President Arline Bradley, you mentioned the many attacks that we are seeing after that ruling. And it's not just in higher education. We are seeing attacks to workplace diversity programs. We're seeing attacks to contracting programs that provide funding to Black-owned businesses, to women-owned businesses. And we're going to continue seeing the attacks. When I was on this panel the last time, I probably said something along the lines of the ruling in the affirmative action case was limited to higher education, right? And that still holds true. But what we anticipated seeing was the conservative right taking that ruling and starting to apply it to different contexts, right? And so while the law has not changed under Title VII of the Civil Rights Act, for example, the law that prohibits discrimination in the workplace, we're going to see an uptick in attacks to workplace DEI programs. While it did not change the law in the contracting space, right? Section 1981, still, that remained untouched by this ruling. We're going to see more attacks. And so we are doing a lot of work to ensure that folks understand the limits of the ruling, the fact that it was a negative ruling, it calls upon us to continue highlighting for the public the importance of diversity, not just in higher education, but in other contexts, in the workplace, et cetera, and to ensure that entities are reviewing their programs to ensure that they are lawful, but that they're not retreating from their programs, that they are continuing to advance diversity, equity, and inclusion, because it's so critically important. In the higher education context, diversity is so important because universities are tasked with training the leaders of tomorrow, right? And it's so critically important for students to hear different perspectives when they are on campus. It is of no benefit to anyone to only hear an echo chamber. Diversity, it's a matter of dignity, right? In a multiracial democracy, everyone deserves to be valued, to pursue their dreams, to advance progress together. Even before the ruling, educational institutions have always had a moral, ethical, and legal duty to promote equal opportunity. And that is especially true now in the wake of the Supreme Court's negative ruling. At the Lawyers Committee, we do work every single day to ensure that no student groups are excluded from those opportunities. My colleague, David Hinojosa, masterfully argued the case on behalf of a diverse student group from UNC. And he very masterfully presented to the court the benefits, the many benefits of diversity on college campuses. And so we're doing a lot of work to provide recommendations to higher education institutions, but also to employers on the steps that they need to be taking now in the wake of this ruling, and really calling upon them, again, to not retreat, to keep their foot on the pedal and to continue moving forward, because so much research shows the benefits of diversity. There's a lot of research showing that by engaging in diverse teams, they are more likely to engage in more rigorous and thoughtful decision-making. They are more likely to uplift different perspectives, to be better problem solvers, to reduce biases, et cetera. So we know that diversity is important for our country. We cannot go back to a history where our college campuses are segregated, to a history where our workplaces are segregated. We need to continue pushing forward.
And let me just say this, so a couple of folks are highlighting this in our Q&A around the effect of overturning affirmative action, noticing in the state of California, seeing reduction in enrollments and decline for applicants from underrepresented groups. And I see the note about the 8A program. So this is not just about, again, higher education. The 8A program, for those that understand the business world, know that the 8A program has set aside dollars that provide opportunities for minority and women-owned businesses. And that totally affects, I see you, Sister Bagley, affects the ability for women-owned businesses to win federal contracts. And so this idea of protecting business, protecting Black women's interests is a big part of this discussion. I see Deborah Tucker's here from Colorado. We're getting a lot of notes from all across the country. And I wanted to be sure that we tapped into this affirmative action conversation. And that, let me just connect it to this discussion, because as we're thinking about affirmative action, which is race-based work that we're specifically talking about for those cases, I also want to deal with this issue around intersectionality. And let me tell you what I'm thinking here, and we talked about this in our last session, but bringing it back up because we talked about this idea of protected class, discrimination against protected classes. So can we give some more context here? What does intersectionality mean? Shout out to Kimberly Crenshaw, by the way, who is out there doing the work, killing the game with the Freedom to Learn Network. Why is intersectionality so important to the progress of marginalized people? And with the Supreme Court ruling in a case regarding discrimination against protected classes, what should our listeners know about what that means for us? Thinking about Black women, are we a protected class, by the way? Can we kind of clarify some of this? Anybody want to jump in there?
Well, race and gender are both protected classes. I think it's interesting to note, though, that when you talk about doing affirmative action that would benefit people because of their race, those programs are subject to a strict scrutiny standard of review, and gender programs are only subjected to a ordinary standard of review. And so you have to ask yourself, why is that? There are a lot of historic reasons. But I wanted to just share one thing about affirmative action before we go on. There are 12 colleges in the United States, the Ivy League, and a handful of others, 4 or 5 others, Stanford, Duke, MIT, where 25% of all 50% of Supreme Court justices come from. Let me find the numbers, because
Please,
it is
yes.
amazing that those 12 institutions carry that kind of weight. You might say, I don't really care about affirmative action. I'm not trying to, I don't care about being in an all-white environment. I just go to an HBCU. But like Ginsburg wrote, the paths to leadership have to be open to people of talent all over the country. And so when we talk about a handful of schools where you get the best jobs, they produce 15% of the people who are in the top 1/10 of 1% of earners. That's not a level playing field. And then you add legacy to that, legacy admissions, and you add overweight on things like essays and what kind of trips you took and what kind of experiences you've had and what private school you went to. Then you realize that the court really had blinders on when they talk about affirmative action, because it's really about leadership and influence, particularly in places like New York and Washington and California. So I'll get off that bandwagon, but it's important.
It is very important. Go ahead, Tona.
Well, I was just going to chime in to the intersectionality point to take us back to the case we talked about in the last session, 303 Creative. That was a case where the Supreme Court held that the owner of a website design studio had a First Amendment right to deny her services for wedding websites involving same-sex couples. And that's in spite of the fact that the state of Colorado had this anti-discrimination law where businesses, places of public accommodation cannot discriminate against someone based on their race, gender, sexual orientation. And when we think about intersectionality, the one thing about this ruling that I think is so devastating really is that it will not only impact LGBTQ communities, but it impacts intersectional communities, such as Black LGBTQ plus communities. And so those are folks who already face discrimination based not just on their sexual orientation, but also based on their race. And I want to cite a survey, which I think is a sad number. 77% of Black LGBTQ plus adults report discrimination adversely impacting their psychological well-being. And that's a rate 50% higher than the total LGBTQ population that was surveyed. So when we talk about intersectionality and the compounding nature of discrimination based on multiple parts of one's identity, I think it can really highlight some of the danger of a decision like this. So I think in spite of this ruling by the Supreme Court, I think we still have to fight to sort of against these attacks that affect communities, and we have to stand up for the dignity and civil rights of all communities, because I don't think we should be thinking about this in terms of a division of, does it impact me because of my race or my gender or my sexual orientation? We have to fight for all parts of our communities and ensure that everyone's civil rights are protected.
Yeah, I agree with everything that Tona just mentioned now. And I do think that organizations like the Lawyers Committee, LDF, and CNW, we have an obligation to look at these various, civil rights issues, student debt, abortion, public accommodation discrimination, workplace discrimination through an intersectional lens. And you mentioned Kimberly Crenshaw. I remember reading Kimberly Crenshaw when I was an NYU freshman, and just sort of the light bulb going off, right? Sort of just understanding, okay, wow, this is what it means to experience discrimination, both on the basis of my race and my gender. these interlocking oppressions, right, that kind of dictate how you experience your day-to-day life. And I really have tried to bring that perspective into the work that I do on a day-to-day basis. But that sort of approach, Kimberly Crenshaw coins the term, but that approach has been implemented, utilized by Black feminists way before Kimberly Crenshaw, including scholars like Polly Murray, who graduated from Howard Law and helped found the National Organization for Women. Polly Murray is someone that we cited extensively in a brief that we filed in the Bostock case, which involved a challenge under Title VII of the Civil Rights Act. And that was the case where the Supreme Court found that Title VII did cover discrimination on the basis of sexual orientation. Polly Murray was someone who, when Title VII was being passed, argued that it's not enough to just prohibit discrimination on the basis of race, because if you're a Black woman, you're experiencing discrimination at the intersection of race and gender. So it's really important for our federal laws to cover all protected bases, because we don't experience discrimination in that way, right? We experience discrimination as a complete person. In the 303 Creative case, we filed an amicus brief, and I just wanted to share one statistic to add onto the one that Tona mentioned, dealing specifically with the discrimination that LGBTQ people of color experience in public accommodations specifically. There was a survey that found that 36% of LGBTQ people of color avoid public spaces like stores or restaurants, and that 21% report avoiding getting necessary services for themselves or their families, or avoiding travel to not experience discrimination. So that just highlights the real critical importance of state and federal laws that prohibit discrimination, including in public accommodations.
Yeah, and I see all the shout outs in the Q&A about this. And let me just say, I'm interested because I'm going to ask this question. And as we're kind of preparing towards the close of the panel, the 2020 elections, okay? Let's talk about this. And let's connect this to what we're seeing now. Many of these decisions, these court decisions, were made despite record high voter turnout in 2020, right? We talked about elections having consequences. Let's think about it. In 2016, there was an election, there was a vote that happened, and we found that the Supreme Court looked different. There were two major appointments that happened between 2016 and 2020. In that shifted the court's attention towards certain values that may or may not align with those of us that are on this call. Now we saw that historic election in 2020. We have an African-American woman who's sitting in the seat of vice president. We have Joe Biden as the president of the United States. And even after all of that, the 2022 midterm elections, they weren't as bad as we thought. That's what people were saying. Well, we're here now. And even though we had all of those record turnouts in 2020, more turnout than we thought in 2022, despite all of that, what would you say to those who are feeling politically disengaged due to their rights being slowly eradicated by a racist and sexist political agenda? Because listen, we are here, and despite all of that greatness, we are still seeing these types of decisions happen. So I want the three of you to weigh in on this, because I want our listeners to get a sense of what does this mean now that we are preparing ourselves for 2024, but still seeing this agenda really travel across the country.
Yeah, I mean, I just want to your important point, President Arline Bradley, the courts matter, and advocacy in front of the courts matter tremendously. And I know that we're seeing this lack of confidence in what our courts can do in terms of vindicating the civil rights of Americans, of Black Americans, of Black women. But I think what remains true in spite of the reality we face today, is that voting is the foundation of our democracy, right? And so I think one of the things that's so important and why elections have consequences is because elections can determine the makeup of our courts. Certainly, we've seen that with respect to what happens at the Supreme Court and the federal court level in terms of appointments that are made by whichever president and party is in power, but it matters at the state and local level as well. And oftentimes there are elected judicial officers in different state and local jurisdictions. So it's important. Voting is so critically important and matters, and it's not just in our federal elections, but it's also in those very important state and local elections where it really matters and where we have to continue to make our voices heard. Black women have some of the highest voter turnout stats and numbers of any other population in this country. And so I think we have to continue to make our voices heard in the way that we vote in our elections.
Yeah, shout out to the Black women, by the way, for saving democracy. Yes, yes, yes. And let's Darielle, jump in, and then we'll close out with Janice.
Yep, just super quickly, elections really matter because there's obviously a huge focus on what happens at the Supreme Court, but presidents nominate not just those who sit on the Supreme Court, but also at the lower federal courts, yes, the district courts, the appellate courts. And in the past few weeks and months, we've seen the Senate confirm several judicial nominees who have progressive backgrounds as worker rights attorneys, public defenders, reproductive rights attorneys, civil rights attorneys, Julie Reichelman, Dale Ho, Nancy Abadou, Myrna Perez. These are some of the judges who have been confirmed, who have been nominated by the Biden administration and confirmed. And it's so critically important that they are now on our courts. And abortion, right? Abortion is a case that the Supreme Court took up, and they said, okay, now it's back on the states. And that's another reason why elections are so important. We've seen in a couple of states, conservative states, where there have been blocks on really extreme abortion bans. So I think abortion is an issue that really highlights just how critically important elections at the local level are.
I would just add that don't get weary in well-doing.
That's right.
The most important thing a president does for the future of the country is appointing judges up and down the line. If the twice impeached, 3 times indicted former president is going to be held to account, it looks as if there is a woman of color on the bench in the District of Columbia, appointed by somebody that we voted for, who will see to it that justice is meted out fairly and evenly. Slavery was its most brutal and most despicable just before it ended. The fugitive slave law was passed on the eve of the Civil War and prompted it. The reason we're suffering such a backlash is because others see our power and they are threatened by it. So don't be weary in well-doing. Keep voting, keep organizing. I know it feels as if sometimes we're doing it for nothing, but Mitch McConnell wouldn't have deprived Barack Obama of an appointment on the Supreme Court if he had not understood just how powerful that was and what it meant. And I'm telling you, if you want to be inspired, read Ketanji Brown Jackson's opinions. You know, plow through the legalese. She's swinging for the fences and she's swinging for the future, and it's worth having her there. So don't be weary, my sisters. It may be for our children or our grandchildren, but it's worth the battle.
So you just opened up a can of worms there, Janice Mathis. We are ecstatic about having the Supreme Court Justice Ketanji Brown Jackson there. She is and does represent her community. I did a speech not too long ago saying that we do have 3 African Americans, but 2 that have consciousness about African Americans. And I think that is the reality of our court. I will always honor the position, but I can't honor the folks that don't have the passion for the people. And I think that we are seeing in this current day and time where Black women, you have a role, you have an opportunity to engage. So I want to just say this. We talked about this in our last segment. We're trying to get Rev on. I believe he is in the waiting room, or he is somewhere close. So we just tried to send him the link again. He was in and I think got knocked out. And I know there are storms coming that way. But I just want to close with this. You all heard us talk about these Supreme Court cases. I'm not going to forget the Dobbs decision because it is an important decision to consider. For those that are logged on, you will see in the chat, and I see Rev has joined us. We're going to jump to him in a second. We have completed and released our reproductive rights position statement. For those that asked for it before, we are giving it to you again. Many of you asked how you could do that, particularly for those that are in the faith community. We do have a position statement ready for you to use if you need to. So to my sisters from the LDF, my sisters from the Lawyers Committee, and Sister Janice, thank you. We are ecstatic about your presence tonight. We have over 400 people on, and there's more on Facebook Live that are calling in. And I'm going to turn it over to someone who I have had a great opportunity to get to know these last few months. Reverend Al Sharpton has been in this fight for a very long time. He is a friend to us in the movement. He is also someone who has been at the forefront and guiding us in this space. But he is also a friend to Black women in this work. He is someone who was a young civil rights leader. So he and I laughed about that already, being one of the younger folks that had to engage in this space. And for those that sent the questions earlier about the March on Washington, so there was a question that came through Rev that said, why are we marching on Washington? And I said, well, you're going to find out tonight while we are commemorating one of the most historic pieces of civil rights advocacy ever to be on record in this country. I want to introduce to some and present to others the Reverend Al Sharpton with the National Action Network. Reverend Sharpton, thank you for accepting to come on tonight to be with the sisters and the brothers that are here from NCNW. We're on Facebook Live. We've got folks on the line. We just wanted to open the floor for you. Give us some insight. Why are we marching on Washington? What are we going to be doing? Why are we there? And why do we still need to continue to mobilize? Rev, I'm going to turn it over to you.
Well, thank you. And thank you so much for this opportunity. And thank you for your leadership and how you have been a real fresh breath of fresh air to civil rights leadership around this country with your leadership at NCNW as well as in your ministry. Let me say that there has not been a time in the last 60 years since the August of 1963 march that we have seen the things that were gained after the march and the eras after under threat like we have seen today. We're not talking about what they could do. They are doing it. They have, in this last few months, they have killed affirmative action in many ways. They have taken away women's right to choose. Hate crimes have gone up among for Blacks, for LGBTQ, for women, and for Jews. And we felt that it was Martin Luther King III and Andrea Waters King, who had Drum Major Institute and National Action Network, wanted to call the civil rights leadership together, which includes you, and reach out to our people in other groups, Anti-Defamation League, women's groups, labor, and say that just like in '63, they had a show of force that set the climate. Medgar had just been killed in that June. It set the climate why they needed the Civil Rights Act of '64 and the '65 Voting Rights Act. We need to put a visible, multi-racial component together of thousands of us that will come to Washington and stand on the same ground that NCNW and the Urban League and NAACP and SCLC and others did, SNCC did 60 years ago, to say we must fight back against what they've done to Blacks and others with affirmative action, to women with rights of the rights of their bodies, with hate crimes and gun violence. And we've not shown that. We look at the news every day. I do a TV show and radio show. Every day, 50,000 people showed up for Trump somewhere, tens of thousands another. Where have we shown a collective body so that those in Washington will say, wait a minute, people are rising up, people are outraged at what's going on. There must be a collective effort. Unlike the '63 march, women will be major speakers. You're one of them. Gays will be involved. We're going to have people from different diverse backgrounds, but Black people, Black leadership must be out front and say that on these sacred grounds, 60 years ago, everyone came together. Everybody talks about Dr. King having the dream, but they don't talk about what Dr. King said. First of all, why are we going to Lincoln Memorial? 11 o'clock, August 26th, that Saturday. Why are we going to Lincoln Memorial? Well, why did Dr. King and Roy Wilkins and Whitney Young and others go to Lincoln Memorial? Why didn't they go to the Washington Monument? Why didn't they go to the Jefferson Memorial? Because King said in that speech that we're here, Mr. Lincoln, 100 years later. In 1863, you promised with the Emancipation Proclamation, equal rights. You promised our citizenship that we would be brought in. And America gave us a check that bounced in the Bank of Justice. We're going to Lincoln Memorial to say what Lincoln promised is now being taken back with Supreme Court decisions, with legislation. They're eroding our right to vote and making impediments all over this country. So we're going right where Lincoln promised, the 16th president, where we're seeing an open attempt by the 45th president to undermine votes that even his aides told him were there. We're seeing openly there having not only the Supreme Court taking women's right to choose, but states doing it state by state voting rights, state by state saying we're going to do what Florida is doing, try and in many ways edit and erase parts of Black history. Where has been a collective response? Without our showing a collective, nonviolent, but very, very dramatic response, it will give the body politic that we are muted and that we are disorganized and we can't come together. So I really, really hope that all the listening make their way to Washington, make their way to stand with NW and all of us. This is not a Martin King III march or an Al Sharpton march. This is our march. This is everybody, because we are all under attack. We may not agree on footnotes, but we all agree on the things that I've talked about just now. And we need to show it by standing up, standing together, and showing our collective disdain for them trying to take back what was given to us. I flew in today, and I'll end with this. I flew today down to Edgefield, South Carolina. A newspaper in New York a couple of years ago did a research and said that they wanted to know if I had a problem with them searching my family's background. I said, no problem. They came back 2 weeks later and said, do you know your grandfather and your father's name, father's side name? I said, yeah, Coleman Sharpton. I met him a few times. He was in Wabassa, Florida. They said, did you know his father? I said, no. He said, well, your great-grandfather, his father, was Coleman Sharpton Sr. Your grandfather was Coleman Sharpton Jr. And your great-grandfather was a slave in Edgefield, South Carolina. The way we found out is there was a deed when Alexander Sharpton, who owned him, died. His wife sold him to some people in Florida. That's how we picked it up. I went to where my great-grandfather was a slave. A collector had kept the plantation, including the shack. And it became real personal to me. Here is my blood that was in that shack. And then we went to the cemetery. The wife of my great-grandfather's owner was named Anna Thurman Sharpton, who was a distant relative of Strom Thurmond. And in the cemetery by the First Baptist Church there in Edgefield, I just left there a few hours ago, are tombstones of Thurmans and Sharptons. They didn't give slaves tombstones. I don't know where they are. So this is real. I'm talking just 3 generations ago. DeSantis and them wants to wipe that out. We owe it to our great-grandparents, our grandparents. We owe it to those that marched in '63 that opened up America. We went from slave shacks to putting a black man in the White House and a woman now as vice president. We're going to let all this go. We're going to let them make all these rulings and we don't respond. There's no mass gathering. There's no energy. There's no way we come together collective. We all should say, not on my watch. Whatever I have to do, I'm going to stand up one day and be counted, and then do the follow-up working with all of our organizations to do the things you've been talking about on the panel. So whether it's Janae Nelson or you or whoever, women have got to be a front and center, not standing back saying amen while we're preaching, but all of us standing up and saying together, we're not going to be silent. We're going to stand up with dignity. We're going to show you we're not January 6th. We didn't come to destroy, but we're going to stand up to rebuild and make Lincoln's heirs keep the promise that America was about. The whole American Revolution was they didn't want autocracy from Great Britain. And none of those presidents ever tried after they won that to overturn an election. How are we sitting here and arguing about whether or not, most people that say to me, Reverend Al, I'm tired of marching. I said, what is the last march you've been to? And most of them haven't been to a march. You can't be tired of something you never did. We've not shown this kind of outrage and this kind of concern. We need to do it together on August 26th. I thank you for this opportunity, Siobhan.
Listen, Rev, thank you so much. It's already in the chat. I already see you all going up. The March link is in the chat. We've got folks on Facebook Live, over 400 that are on this webinar right now, others that are online watching. We want all of you to please register. We have a registration link. We're working very closely with the National Action Network as a co-sponsor. We now have young people that have now planned on joining our march. We have collegiate sections. The Divine Nine, we set up a meeting. The Divine Nine is meeting tomorrow with the National Action Network. So my Divine Nine sorors on the line. The Links Incorporated are planning on coming. We're sending folks from all over the country. So in partnership with National Action Network and the Drum Major Institute, Rev, thank you. Thank you for landing and still coming online because we know how important this is. And to my brothers and sisters that are logging in, yes, the link is in the chat. You can register tonight so that we can get a count of how many of you are going to be coming so we can share it with the NAN family. And also for those that are living with a disability, we have decided to provide space even at NCNW's headquarters, which is right down the street. We're going to have water for persons who may be living with a disability or using a mobile device like a wheelchair or a cane. If you have challenges, we're going to have folks there that have water for our seniors and persons that may not be able to walk. We will have space and support the march that way as well. Folks are going to be in their purple, Red. We're going to have purple shirts. We're putting out our order. Please wear your purple NCNW shirts. If you are part of an organization, a Divine Nine organization, a civic organization, wear your hat and your purple shirt. We want to see all the colors in the room. I know that the Phi Beta Sigma is going to be there. I know that Delta Sigma Theta, Alpha Kappa Alpha's coming. The Zetas are coming. We've already got those calls. So we are excited to join you. And just in honoring Dr. Height in this moment, I just want to do this before we hang up. We know that she was a major architect behind the closed doors. Many people don't know the story about Dorothy Irene Height, but she was the one that kept the glue together. When there were arguments in that back room, even as they were getting on stage, Dorothy Height actually submitted her time to ensure that young people had a place. The only person that actually got a chance to really present was folks like John Lewis. He was the youngest person actually on that stage. And you think about the actual contributions of Black women at that time. I wanted to say 60 years later, it would be a different program. It'll be a different program. We will have sisters up there, young people up there, persons that are living with disabilities, persons that are in the ministry, persons that may or may not even believe what you believe, but we're aligned around this issue. And that is voting rights, freedom, access to constitutional freedom that Black people have fought for since we've landed on these shores. Reverend Sharpton, thank you. I know it was rough you getting on the flight and getting here, but thank you. We appreciate you. We love you. NCNW folks, I see you in the chat. Thank you for logging in. To the panelists, what a night, y'all. We've done it again. Thank you so much. We love you from NCNW. Y'all be blessed tonight. And don't forget, use the link, sign up for the march tonight. God bless everybody and have a great night, everyone.